Fortuitous event, Article 1174. Fortuitous event under the same provision is an event which could not be foreseen, or which, though foreseen, is inevitable. In order for fortuitous event to be accepted as a justification for non-performance of an obligation, the following must be present. 1. The cause of the unforeseen and unexpected occurrence or of the failure of the debtor to comply with his obligation must be independent of the human will. 2. It must be impossible to foresee the event which constitutes the cause of fortuito, or, if it can be foreseen, it must be impossible to avoid. 3. The occurrence must be such as to render it impossible for the debtor to fulfill his obligation in a normal manner. And 4th, the obligor must be free from any participation in the aggravation of the injury resulting to the creditor. Letter A. The period during the bank cannot do business due to insolvency is not a fortuitous event, unless it is shown that the government's action to place the bank under receivership or liquidation proceedings is tainted with arbitrariness, or that the regulatory board has acted without jurisdiction. When there is liability, even if there is fortuitous event, in the obligation to deliver or to give, the debtor shall be liable for any loss due to fortuitous event which occurred before delivery in the following instances. 1. The obligor or creditor delays. 2. The obligor or debtor promised to same thing to two or more persons who do not have the same interest. 3. When there is stipulation or agreement that the obligor will not be excused. 4. If there is assumption of risk as required by the nature of obligation. And 5. Where the thing to be delivered is generic. And 6. Where the obligor is also at fault, the fortuitous event is in effect humanized. 7. The nature of obligation makes the obligor liable. Example, insurance. 8. The law makes the obligor liable. And 10. Liability from delict. Problem. AB Corp. Entered into a contract with XY Corp., whereby the former agreed to construct the research and laboratory facilities of the latter. Under the terms of the contract, AB Corp. Agreed to complete the facility in 18 months at the total contract price of $10 million. XY Corp. Paid 50% of the total contract price, the balance to be paid upon completion of the work. The work started immediately, but AB Corp. Later experienced work slippage because of labor unrest in its company. AB Corp.'s employees claim that they are not being paid on time. Hence, the work slowed down. As of the 17th month, work was only 45% completed. AB Corp. Asked for extension of time, claiming that its labor problem is a case of fortuitous event, but this was denied by XY Corp. When it became certain that the construction could not be finished on time, XY Corp. Sent written notice canceling the contract and requiring AB Corp. To immediately vacate the premises. Letter A. Can the labor unrest be considered a fortuitous event? B. Can XY Corp. Unilaterally and immediately cancel the contract? Letter C. Must AB Corp. Return the 50% down payment lifted from 2008 bar? Letter A. No. Labor unrest is not a fortuitous event. AB Corp. Is not excused from complying with its obligation of constructing the research and laboratory facilities of XY Corp. The labor unrest is not impossible to foresee because it was caused by the AB Corporation's non-compliance with its legal obligation to the workers. Letter B. No. XY Corp. Cannot unilaterally and immediately cancel the contract. The case involves reciprocal obligations on the part of AB Corporation and XY Corporation, while under Article 1191 of the new Civil Code, the power to rescind is implied for reciprocal obligations. The rescission contemplated under the same provision is judicial rescission. Rescission can be resorted by filing a case in court for such purpose. Letter C. No, AB Corporation did not return the entire 50% down payment. The principle of quantum merit is applicable. The problem states that 47% of the project was completed. Hence, AB Corporation can retain the amount corresponding to this percentage of accomplishment. However, AB Corporation must return the balance and must pay damages incurred by XY Corp because AB Corporation's breach of its obligation. Jane brought her diamond ring to a jewelry shop for cleaning. The jewelry shop undertook to return the ring by February 1, 2020. When the set date arrived, the jewelry shop informed Jane that the job was not yet finished. They asked her to return 5 days after. On February 6, 2020, Jane went to the shop to claim the ring, but she was informed that the same was stolen by a thief who entered the shop the night before. Jane filed an action for damages against the jewelry shop, which put up the defense of force majeure. Will the action prosper or not? The action will prosper. Article 1165 of the new Civil Code provides that if the plicore delays, he shall be responsible for any fortuitous event until he has effected delivery. Thus, even assuming for the sake of argument that the theft of the ring can be considered fortuitous event, the jewelry shop is still liable because there was already delay when the theft occurred. Liability to pay interest. A creditor may compel the payment of interest in obligations arising from contracts if the following requisites are present. 1. There is an agreement that the interest shall be earned. Number 2. The agreement that interest shall be due shall be expressly stipulated in writing. And 3. The rate of interest must not be usurious or excessive or unconscionable. Kinds of interest. Monetary interest. Compensation for the use of money, monetary interest, under Article 1956 of the new Civil Code. Monetary interest refers to the price paid for the use of money for a period of time and are expressed as a percentage of the total outstanding balance that is either fixed or variable. There are two ways by which interest rates can be defined. First, from the point of view of a borrower, it is the cost of borrowing money, borrowing rate, and second, from a lender's point of view, it is the fee charged for lending money, lending rate. Compensatory interest. Interest as damages under Articles 2209, 2210, 2211, and 2212 of the new Civil Code. Presumptions. Article 1176. It is prima facie presumed, or there is disputable presumption that a. When the creditor perceives the principal without reservation with respect to the interest, said interest has been paid. When the creditor receives installation of a debt without reservation as to prior installments, such prior installments have been paid. Usury. Usurious transaction is a transaction which provides for interest that is above the maximum rate of interest provided by law. For example, if the law provides that the rate of interest on loans cannot be more than 20% per annum, the loan is usurious if the rate of interest that is stipulated is 30% per annum. Governing law. The special law that governs usurious transactions is Act No. 2655 as amended, otherwise known as the Usury Law. B. Legally non-existent. However, usury is legally non-existent today because in 1983, the central bank, now called Bangko Sentral ng Pilipinas, lifted the ceiling on interest rates. In other words, there is no longer any maximum rate of interest. 1. If usury is legally existent, an apparently lawful loan is usurious when the real interest agreed upon is usurious. For example, there is still usury if there is an additional compensation disguised by an ostensible unrelated promise that is, in fact, not to be performed. Number 2. In usurious transaction, the entire obligation does not become void, but only the interest. Unconscionable. Even if usury is non-existent, an interest rate agreed upon by the parties may be declared void for being unconscionable or grossly excessive. In Medell v. Court of Appeals, the Supreme Court ruled that the stipulated interest rate of 66% per annum or 5.5% per month on a $500,000 loan was excessive, unconscionable, and exorbitant, hence contrary to morals, if not against the law, and declared such stipulation void. In Toring v. Spouses, Ganson, Olan, the court found stipulated interest rates of 3% and 3.81% per month on a $10 million loan to be excessive and reduced the same to 1% per month. In Chua v. Timan, the stipulated interest rate of 7% and 5% a month, which are equivalent to 84% and 60% per annum, respectively, were reduced by the Supreme Court to 1% per month, or 12% per annum. The court said that stipulated interest rates of 3% per month and higher are excessive, unconscionable, and exorbitant, hence the stipulation was void for being contrary to morals. However, the Supreme Court ruled on interest rate of 23 or 24 per annum is not unconscionable or excessive. Legal interest. The debtor shall be liable to pay interest in the following cases. 1. If there is agreement that interest will be paid, but there is no agreement as to the rate thereof. 2. From the time of delay or default in an obligation consisting of payment of a sum of money, even if no interest was agreed upon, usually counted from judicial demand. 3. From the time decision in favor of the creditor for the enforcement of an obligation for a sum of money becomes final and executory, because the obligation, even if originally not a loan or forbearance of money or credit, becomes an equivalent of forbearance of money or credit from such time. 4. The interest due shall also earn legal interest from the time it has been judicially or extrajudicially demanded. Rate. The legal rate of interest is now 6%, both for loans and forbearance of money, and for obligations that are not loans and forbearance of money. Remedies of the creditor. If there is non-compliance with the obligation of the debtor or obligor, the law gives the creditor or obligee the remedies specified below. It should be noted, however, that these remedies are mainly judicial in nature. Principal remedies. A. Specific performance. Articles 1165 and 1167. Remedy for requiring exact performance of a contract in the specific form in which it was made, or according to the precise terms agreed upon. It is the actual accomplishment of a contract by a party bound to fulfill it. B. Substitute performance. Article 1165. Letter C. Equivalent performance. Articles 1168 and 1170. Subsidiary remedies. A. Subrogatory action or action subrogatoria. Article 1177. The creditor will file a case in behalf of the debtor with respect to another obligation that is due to the debtor. This is a case against the debtor's debtor. Letter B. Rescissory action or action Poliana. Article 1177 and 1381. The creditor will impugn the acts of the debtor that is in fraud of creditors. This is a case against the transferee. Action directa. There are provisions of the Civil Code that allows direct actions against third persons, including those provided for under Article 1652, lesser against the sublessee for unpaid rentals. Article 1608, vendor's right against the possessor. Article 1729, supplier of labor or materials to contractor. And Article 1893, principle against the substitute of an agent. Requisites of subrogatory action. The requisites for the filing of subrogatory actions are as follows. 1. The creditor has a right of credit against the debtor, although at the moment it is not liquidated. Number 2, the credit must be due and demandable. Number 3, there must be failure of the debtor to collect from third persons, debtor of the debtor, whether willfully or through negligence. Number 4, the assets in the hands of the debtor are insufficient. The creditor need not bring a separate action to show this exhaustion or insolvency of the debtor, but he can prove the same in the very action to exercise the subrogatory action. And fifth, the right and actions are not purely personal or inherent in the person of the debtor. Requisites of rescissory action, action Pauliana. The requisites for the filing of rescissory action are as follows: that the plaintiff asking for rescission has a credit prior to the alienation, although demandable later. 2. That the debtor has made a subsequent contract conveying a patrimonial benefit to a third person. 3. That the creditor has no other legal remedy to satisfy his claim, but would benefit by rescission of the conveyance to the third person. Letter number 4. That the act being impugned is fraudulent. Number 5. That the third person who received the property conveyed, if by onerous title, has been an accomplice in the fraud. Subsidiary. Rescissory action is also an action for rescission, but it is subsidiary in nature. This should be distinguished from and is not the same as the rescission with respect to reciprocal obligations under Article 1191 and rescission of some of the rescissible contracts under 1831, number 1 and 2. Rescission under Articles 1191 and 1831, 1 and 2 are principal actions. Letter B. The action Pauliana is an action of a last resort. For as long as the creditor still has a remedy at law for the enforcement of his claim against the debtor, the creditor will not have any cause of action against the creditor for rescission of the contracts entered into by and between the debtor and another person or persons. Indeed, an action Pauliana presupposes the judgment and the issuance by the trial court of a writ of execution for the satisfaction of the judgment and the failure of the sheriff to enforce and satisfy the judgment of the court. Transmissible rights. A right may be considered property. Thus, the right to collect a demandable sum is property. As such property, it can be transferred from one person to another, and this fact is recognized in Article 1178. Non-transmissible rights. By way of exception, a right is not transmissible in the following instances. 1. When there is a stipulation that the right cannot be transferred. Number 2. When the law or contract requires prior consent before transfer and no such consent was acquired. Number 3. When the law expressly prohibits transfer and when the right is purely personal. Number 4.